So good morning, everyone. I should first point out that this session is being recorded, and whilst you can see us, we cannot see you. My name is Andrea Lynch, and I'm a Principal Associate specialising in construction and engineering risks within our insurance disputes practice area. I am joined this morning by my colleagues, Adrian Kwintner and Andrea McConnell, who also specialise in construction and engineering risks. Morning, both.
Morning.
Morning, Andrea.
So today we are discussing collateral warranties. In this session, we will look at what collateral warranties are, why they are important, and highlight some of the hidden nasties which can be found in the wording of warranties that construction professionals are often asked to agree. We will finish up this session this morning by looking at net contribution clauses, which are a common feature of collateral warranties. So Adrian, I think to get us started this morning, it would be really helpful if you could just first explain what exactly is a collateral warranty.
Well, Andrea, at its simplest, a collateral warranty is a contract between a construction professional and a third party, which gives the third party a right to sue the professional in circumstances where a right to sue would not normally exist. So on this slide, we have a diagram of how a traditional construction contract is set up. If we take the collateral warranties out of the picture, you'll see there is no direct contract in place between the design team and the university, nor is there any contract in place between the university and the specialist subcontractor. But with the collateral warranties in the picture, the university has a contractual relationship with both the design team and the specialist subcontractor.
Thanks, Adrian, that's really helpful. So we can see what collateral warranties are, but why are they so important?
So I'll take that point. Thanks, Andrea. So the answer lies in the university's ability to sue if a defect comes to light several years after practical completion of the project. So in circumstances where there's a direct contractual relationship in place, for example, between the SPV and the contractor in our scenario, then if a problem arises, the SPV has the option of suing the contractor in either contract or in tort, i.e. in negligence. In addition, the contractor also owes a duty to protect the SPV against what is known as a pure economic loss. In other words, not just damage to people or property, but also financial loss, such as the cost of remedial works.
Okay, but what happens if the building has been handed over to the university before the defect is discovered, or if the SPV or the contractor has gone bust? Can the university sue the design team direct if it was their mistake that led to the defect?
Well, that's a good question, Andrea. And the good news for the university is that the design team will owe a duty in tort to all persons likely to suffer loss if they are negligent. And that includes the university as the ultimate occupier of the building. So the short answer is yes, the university can sue. However, the general rule is that the design team will not owe the university a duty to protect against pure economic loss. It is obviously a problem for the university.
But why exactly is that a problem for the university?
Well, that's an interesting question. Assuming its claim is successful, the university will be able to recover compensation for any physical damage caused to other property and also any personal injuries caused by the defect. But it won't be able to recover the costs of carrying out works to the building itself in order to rectify the defect. Now, there are various arguments which the university may be able to use in order to get around this problem. Some possible ways are shown on this slide. That's a topic for another day, but perhaps the most common solution is to require the design team to provide a collateral warranty at the outset of the project. This gives the university the right to pursue a claim against the design team in both contract and in tort. It also gives the university the opportunity to recover the contractual measure of damages. In other words, damages to put the university in the position it would have been had the contract been performed correctly. And crucially, this includes pure economic loss and the cost of remedial works.
Great, thanks, Adrian. I think that's a really interesting overview as to why collateral warranties are important, but from a practical perspective, what does a construction professional need to consider when pitching for a new project?
So thanks, Andrea. So construction professionals, as we know, are often asked to sign up to a whole host of collateral warranties at the beginning of a project. And most professional indemnity policies will not cover the professional for any claims arising under a collateral warranty to the extent that the liability is greater than that which would have occurred in any event. So from the professional's point of view, it's absolutely vital that the collateral warranty does not extend their duties and liabilities beyond those already agreed in the contract with the employer. And this, unfortunately, isn't always as easy as it sounds.
Yes. So what should the construction professional be looking for when asked to sign up to a collateral warranty?
Okay, so I think the best way of doing this is to talk through a couple of examples. So the first is fitness for purpose warranties. And generally speaking, the duty of a professional is to exercise reasonable skill and care. And that's obviously a phrase with which we'll all be more than familiar. But it's not a duty to guarantee a particular outcome or result from a project. However, employers and funders will often try to insert clauses into collateral warranties, seeking to impose an obligation that the professional's work will satisfy a particular specification or purpose. And in doing so, the employer increases, or at least tries to increase, the scope of the professional's duties. And an example of why that's important can be found in the case of Greaves Contractors and Bain and Michael. So just to briefly go through that case. An engineer was employed to design the structure of a building known to be subject to vibrating loads. And once built, it transpired that the building couldn't cope with those loads. And the court found that the engineer had actually exercised reasonable skill and care. However, the court still found that the engineer was liable on the basis of an implied warranty that the building would be fit for purpose.
Okay, so the lesson from that case is that a collateral warranty should always refer to the duty of the construction professional to use reasonable care and skill.
Well, yes, that's right. Clearly, it's important that the collateral warranty clarifies that the professional's obligations are subject to a duty to exercise reasonable care and skill, and that the standard expected is that of a reasonably competent professional in that particular area. Another example of why this is important is that warranties sought from subcontractors often require them not to use any prohibited or deleterious materials such as asbestos. This should be amended to a duty to exercise reasonable care and skill.
Okay, but from the university's point of view, it's all very well having these collateral warranties in place, but what happens if they want to sell the building?
That's a good question. A new owner will expect the benefit of the warranties to be included in the sale. The way that's achieved is through a clause which allows the employer or funder to assign the benefit of the rights under the warranty. However, that increases the risk to the professional because it has no control over the assignment or the person it's being given to. For that reason, most professional indemnity policies limit the cover they will provide in relation to claims made by assignees. The policy might only cover claims made by, say, the first two assignees. The professional needs to make sure that this restriction on the number of assignments is also reflected in the warranty. If not, the professional is exposed to the risk of being left without cover.
Thanks, Adrian. So I'm clear on the need, of the need to be clear about assignments, but what about the level of the professional's professional indemnity insurance cover on completion of the project? How should that be reflected in the warranty?
Thanks, Andrea. So I think the university will want to protect itself against the discovery of problems which may only come to light several years after, and down the line. And the university will also want to include a clause requiring the professional to maintain a minimum level of professional indemnity insurance for a set period of time. So that would normally be 12 years from the date of practical completion. And from the professional's point of view, it really is vitally important that the requirements of the warranty match up with the scope of the insuring clause and the indemnity limit in the policy that they've already entered into. For example, if the policy provides £2 million worth of cover for each and every claim or series of claims or in the aggregate, then it's important that this is mirrored by the terms of the collateral warranty being given. In addition, the professional will also want to check that they exclude or limit liability for things like asbestos, contamination, or pollution, or any other things that a professional indemnity policy would ordinarily exclude.
Yeah, thanks, Andrew. So are there any typical clauses that the construction professional should be looking out for?
Yes, there are, and we haven't got time to look at them all, but I've picked 5 to illustrate the point as shown on the slide. The first is where the professional is required to warrant that their designs and drawings do not infringe third-party intellectual property rights. Make sure this is qualified to say to the best of the professional's knowledge. We would also suggest trying to include an equivalent rights of defence clause, which enables the professional to use any defence they would have against the employer under their professional appointment to defend a claim from the beneficiary under the collateral warranty. The third example on the slide is one of the best clauses the professional can include because it limits their liability to the amount recoverable under their professional indemnity policy. This closes off many of the risks we've already highlighted, but for obvious reasons is often met with some resistance. Another really important clause to try to include is a defined time limit for bringing claims under the warranty. These clauses are good because they provide certainty for the professional and their insurers, but be prepared for a battle. One of the reasons a building owner will want warranties is to secure a remedy if defects arise long after completion. In fact, many warranties are drafted as deeds, which means a claim can be brought up to 12 years after the date of the warranty. Last but not least, construction professionals should try to include a net contribution clause, an NCC, in the collateral warranty and also in the appointment contract.
That's really helpful, Adrian. Can one of you explain to our attendees what exactly NCCs are?
I certainly can. So NCCs seek to limit a professional's liability to an amount that the court would consider fair and reasonable, taking into account the responsibility of other parties for the same loss. So NCCs aren't really anything new at all, but there have always been question marks over their enforceability. And NCCs are great from the professional's point of view because they take away the risk of being held 100% liable for a loss, even if they're only partly to blame. However, NCCs are not great from an employer's point of view because they take on the risk of third-party insolvency and they could end up out of pocket as a result. And this was precisely the situation which arose in the Court of Appeal case in 2014 of West and Finlay.
Andrea, I do think it would be helpful if you take us through the facts of that case briefly. As a little heads up to our attendees, we are going to run a poll on what you think the Court of Appeal decided once Andrew outlined the facts for us.
Thanks, Andrea. So I'll try and keep these facts, really simple and go as slowly as I can. And it is an anonymous poll, I should add. So the West engaged in Finlay Associates as architects to redesign the layout of their home on the banks of the Thames. So it's quite a high-end project here. And the West also appointed building contractors, Maurice Armour, to carry out the works. And the project was, according to the Court of Appeal, a total disaster. There was no proper waterproofing, and pretty much all of the M&E installations had to be ripped out and entirely replaced. And the cost of the remedial works was around £800,000, so more than twice the actual value of the original works. And expert evidence showed that the problems were a combination of poor design and poor workmanship. And the contractor's workmanship was clearly responsible for the majority of the defects, but they had gone bust. So the West brought a claim for the whole loss against the architect under the principle that the contractor and the architect were jointly and severally liable for the same loss. And the case then turned on the following clause, which hopefully you can see on the slide, and I'll just go through that now. So this was the key clause, the key net contribution clause. Liability for loss or damage will be limited to the amount that it is reasonable for us, i.e. the architect, to pay in relation to contractual liabilities of other consultants, contractors, and specialists appointed by you, i.e. the clients, Mr. and Mrs. West.
Okay, so now on to our poll. would just like to ask our attendees what they consider the Court of Appeal decided. On the screen, you'll see a number of statements. As Andrew said, this poll is anonymous, so feel free to vote away. So the statements to vote on are, did the Court of Appeal decide that A, the NCC limited the architect's liability because the architect and the West had equal bargaining power? B, did the NCC did not limit the architect's liability because the contract was with a consumer? Or C, the NCC did not limit the architect's liability because the contractor had gone bust? Give everyone a few minutes to have a look at that. Well, we're having a lot of responses come in to that. Okay, it seems that a lot of people are going for C. It's actually quite a mixed response, so it's sort of spread over all three. Wow, a lot of people voting on this one. Okay, I think the numbers seem to be leveling off. So, Adrian, which statement is correct?
Well, the answer is A. The Court of Appeal decided that the clause did serve to limit the architect's liability, provided it didn't fall foul of the unfair terms in Consumer Contract Regulations 1999 or the Unfair Contract Terms Act 1977. On the facts of this case, it didn't fall foul. The key point was whether the clause caused a significant imbalance in the parties' rights and obligations to the detriment of the consumer. The NCC had caused an imbalance, but this wasn't significant, as first, NCCs are prevalent in standard REBA forms. Second, the NCC was not unusual. And third, it was the West who had decided to appoint the contractor. There was no lack of good faith on the part of the architect. It would have been preferable to have drawn it to the West's attention, but this wasn't critical. The parties in this case had equal bargaining power, and the clause was held to be fair. Deciding what was reasonable for the architect to pay would be much the same as assessing what would be just and equitable under Section 2(1) of the Civil Liability Contribution Act of 1978. The judgment confirms that NCCs are in principle enforceable, even in contracts with consumers. And it makes it very difficult for NCCs in non-consumer contracts to be challenged. It is just worth noticing that this case was decided before the Consumer Rights Act 2015, which replaces the Unfair Terms in Consumer Contracts Regulations 1999, and in relation to consumer contracts, the Unfair Contract Terms Act 1977. And so it remains to be seen whether a court will always interpret an NCC in a consumer contract in the same way as the Court of Appeal did in Western Finlay.
Thanks, Adrian. We will definitely have to run another webinar if the court ever does interpret NCCs differently in the future. Thank you both so much for that this morning. That was a really helpful run through of collateral warranties. That's all we have time for today. Thank you so much for joining us this morning. Please do complete the feedback form, which will be on your screens when you sign off. Feel free to include any topics you'd like us to consider speaking about in the future. Do join us on the 18th of May for the next session of Breaking Ground, where colleagues will be discussing workmanship exclusions in professional indemnity policies and the Wayne Tank principle. Thank you so much. We wish you a good rest of the day.